Welcome back to the LawNewz Network. My name is Stephanie L. Willis. I am your host for this afternoon. What we had was a pretty exhaustive list of jury instructions. The judge went through 18 of the charges that Frank Bybee faces at this point. The jury has not been sent back for deliberations yet. They will begin deliberations tomorrow when they come in, and they're scheduled to arrive at 8:30 in the morning, 8:30 a.m. sharp, because we know that this judge is very particular about his time, and he does like to start on time. So we can be assured that it is likely that once the jury members are all in, that jury deliberations will begin soon thereafter. After going through the jury instructions, the state and the defense and the judge also went through the jury verdict form. The jury verdict form is very important, and it was actually a great thing that they went through that today, especially being the fact that court ended a little early today. It's important that they went through that today in order to not waste time tomorrow, so that the members of the jury can just begin deliberations right away. As we were discussing prior to the judge charging the members of the jury with the instructions, we were discussing the importance of jury instructions. And I have live with me today is Adam Sostrin. Adam, how are you?
Hello there. How are you?
I'm great, thanks. Thanks so much for being with us today. If you were able to see, the judge was going through a very exhaustive list of the 18 felonies that Frank Bybee is charged with, including attempted murder, which he could face. There's a potential to face life for the attempted murder. There's exploitation of the elderly, being that Ms. Soule was 79 years old at the time that the alleged events occurred. Burglary, theft, and kidnapping. So what I want to discuss is the importance of actual jury instructions. We know that the judge went through a very exhaustive list. He meticulously went through each charge and provided the definitions to the members of the jury. I explained to our viewers that it's important that, well, not it's important, but that both members, both the state and the defense, both come up with what they believe are important jury instructions. They meet together with the judge, and they decide thereafter which instructions will be provided to the members of the jury. So why don't you explain that a little bit for our viewers?
Well, I mean, the judge sort of has to instruct on the law. The jurors hear a lot of evidence throughout the case, and the prosecution says there's going to be, charges, 1 through 15. The jurors need to understand what's required for the state to prove the elements of every single charge beyond a reasonable doubt. Once the jurors know that, they're able to go back into the deliberation room, and then they make a determination to see whether or not each of those elements for each of those charges, has been proved beyond a reasonable doubt. If of course, one of the elements is missing, there has to be a not guilty on one of the charges, or the jurors can split over it, and it can be sort of a hanging count where there's no conviction.
Okay, great. And I have to say for our jurors, and this is a fault of mine, we have not had closing arguments at this point. Usually the jury instructions, the jury is charged with their instructions after closing arguments are provided by the state and the defense. So that's my fault. But
it happens all the time.
Right, right.
The court wants to do housekeeping at the end of the day. Well, let's just sort of wrap this up. You give your closing argument. The state gives its rebuttal or whatever, and then the jurors can start up on it, rather than the jurors having to hear this huge litany of all these different things after they hear the closing argument. It's not as fresh. So it happens all the time.
Right. Well, what do you think? I mean, and you just made a great point. The fact that the jury members won't have to, after listening to, I believe they each side will have 2 hours for their closing. So after the members of the jury are listening to both sides, so that's 4 hours that we can say altogether if each side uses the amount of time that's allocated to them. What's the importance of, I guess, listening or receiving their charges, their jury instructions prior to the closing arguments rather than after the closing arguments, as it's done in some jurisdictions?
Well, in a lot of ways, it just makes so much sense. Just get through the stuff that's the boring stuff, and then focus on what's been proven in the case? What has the prosecutor proven? And the prosecutor will attempt to show that to you in their closing argument. What is the defense? What have they proven? They'll attempt to show that to you in their closing argument. And then they go back into the room, then they decide, as opposed to having to get all the instructions right after you hear both of those statements. Let's say 4 hours goes by, and then you have another, hour and a half of instructions. It's just not as fresh in their memories. It makes a lot of sense to me to do the closing instructions before and then do the closing statements, so the jurors know what they're looking at, what's important, and they're ready to go. They're ready to start. First thing in the morning, I'm familiar with these kinds of judges. They cause a lot of pressure and headache and heart attack and things like that, but it keeps everybody in line and things get done quick.
Right. And the defense in this case did not put on a very big case. They finished with their case today, and then the prosecution provided one rebuttal witness. It was the lead detective in this case by the name of Cassandra Gaeta, I believe her last name is pronounced. What do you think about the defense putting on a case at all? Do you think that what the prosecution provided in their case in chief was enough for the defense to put on a case here? Because we all know it's not necessary. They don't have to.
It's not necessary, but sometimes it's important to put on defense witnesses. It's often the case that I have something that I want to put on. If it's an expert or if it's one witness, and sometimes it's my client. For the most part, I actually end up putting on somebody, but that's just been the circumstances of my cases. Every single case is different. Some cases it's not required at all. If you're able to poke enough holes to present reasonable doubt, and it's abundantly clear to the jurors who are sitting there, and we hope they're going to be objective once they're chosen. If it's abundantly clear and it's and it makes sense, and if you think you throw out a defense witness, you're just going to ruin your case. It's going to put more holes in your case than the prosecution. Those are the times that you just don't say anything, and you just your goal is just to put holes in the prosecution's case. And but every single case is different.
Right, and that's very true. Every single case is different. You discussed the objectivity of the members of the jury. We know that when this case first began in voir dire, it was very, very difficult for both sides to be able to come up with the jury panel that they have at this point. There were a great deal of prospective jurors that we know that were disqualified because they were actually caretakers, or they informed the judge that it wasn't possible for them to provide a fair and accurate verdict from what they heard because of the fact that this was an elderly woman. Talk to us a little bit how that goes to play when we have voir dire and it's difficult to obtain jury members because of the type of case that it is.
Hey, by the way, did you know, thank God I took high school French, but voir means to see and dire means to say. So I just see what somebody's going to say. I was always so proud of myself that I learned that when I started doing this. All right, that's a side point.
No worries. No, I actually thought that was interesting as well, because I speak French. So whenever I hear it, I'm like, oh, okay, I know what those two words are. So, I mean,
okay, so talk French after this, and I can use my high school French that it's been, 30 years since I've done that with your actual French, and we'll see where we go.
Sounds good.
Jurors have all kinds of biases depending on the charge. For instance, if you have a DUI case, there's a bunch of jurors there that they pay money to organizations like Mothers Against Drunk Driving, or they know somebody who was a victim of a DUI, somebody who was injured, or their brother, their kid had a DUI, or if it's a domestic violence case, there's somebody in that panel that's been abused. It seems to happen every single time, which is a terrible scarlet letter in our society, but it seems like horrible things happen all the time. If the state puts on an elder abuse case, and presumably I'm going to meet somebody who's been a caretaker once or twice in their life, and what you want to do is, as the defense, you want to get rid of those jurors that are going to have those preconceived biases against your client based on their life experience. And the same thing goes with the prosecutor. If there's going to be some juror who's going to be there who says, well, it's really hard for me to find any defendant guilty. It's not for me to judge. So just like any single case, the jurors are going to present The defense is going to say, this guy's good, I want to keep him, or this woman's good, I want to keep her.
Right.
The prosecutor is going to say, okay, great, kick her, kick here, and each party has a certain number of times that they can, they're called peremptories, that they can kick off a juror on the panel.
Right.
And they're limited. But the one thing they can't do it for, and this is sort of like a lesson, I don't know why I'm going as far as, you can't do it for, racial, religious, sex, gender reasons. You can't kick them off for those reasons.
Yeah, because then we'll have a Batson challenge, correct?
Correct. Yeah.
Right. So in this case, we unfortunately we hate to have victims, period, but that's the nature of our society that we live in right now. The victim that we have is 80 years old at this point. She was 79 years old at the time that the alleged acts were committed allegedly by Frank Bybee. Now, the fact that Marsha Soule is 80 years old, we saw her being brought into the witness stand on a wheelchair. How do you think those optics come to play when the jury is looking at this?
Well, I mean, obviously it's helpful for the prosecution.
Right.
It seems to be that this is an ambulatory, helpless individual that somebody could take advantage of. Of course, it was the defense's goal in this case to raise, well, fine, but she has some mental health problems.
Right.
So whatever she says you can't rely on it. So just the fact that she looks like this and appears this way, that shouldn't be enough to sway you. But of course, I'm the defense attorney. I'm sitting there and I see a poor, elderly woman. And I hate saying elderly because I feel like I keep getting older, as the years go by. But I see somebody like that, I'm going to worry that some juror is going to feel for her, and that's going to color how they view the evidence throughout the entire case. And that's what I'm up against. But presumably the defense attorney was aware of this, at the start of the case.
Right. Now, we know that because of her age, there is a possibility, and most likely, that she will have some issues recalling some of the events that occurred. And we saw that during her testimony. She informed, I believe even on direct, that there were some things that she could not recall regarding some doctor's visits. How do you think that will affect this case? Because we know as individuals grow older, even myself, there are a lot of things that I forget. So I can only imagine being a woman at 80 years old, not really recalling or not being able to recall a great deal of things. Now, we know that the defense stated in their opening statements that she provided two versions of this story. So the fact that she could not recall certain things, do you think that may have presented adversely upon the state's case?
Absolutely. Of course, I know what I would do if I were the prosecutor, and I'd say, well, this is an older person and people are forgetful. But when a witness makes conflicting statements, whether or not you feel for them because of their age, it's a type of hole in the prosecutor's case that they need to clear up or that they need to excuse. So, of course, something like that's definitely helpful for the defense.
Right. And we know that I thought that it was great that they had the document analysis by the name of Keisha White, who testified during the trial as well regarding the alleged 4 checks. There were 4 checks that were provided to Frank Bybee. One was a check in the amount of $50,000 that was provided to Frank Bybee himself, and then 3 additional checks in the amount of $5,000 to his sons. Now, I believe Keisha White testified that the drafts appeared to be traced. That doesn't seem like it bodes well for the defense in this case. So how do you think that if you were the defense in this case, how would you combat the allegations made by the state?
I'm sorry, the drafts appear to be traced. Is that what you said?
Correct, meaning that they were fraudulently written by Frank Bybee.
Well, I mean, that's when you go in, ahead of the trial, and you have to have your forensic expert, a handwriting expert, determine whether or not, it appears to be the same. It's not the same. I'm assuming that they did this, and perhaps they had an expert that said it appears to be the same, so they wouldn't call an expert themselves to be able to rebut this. It is definitely, it's definitely not helpful for the defense. Clearly those amounts being so high,
right.
would color the perceptions of the jurors. And what are those checks, of course, doing? How does she know the names of the children, of the defendant in this case? So definitely not helpful.
Another hit to the defense was the fact that Detective Eric Whedon, I believe his last name is pronounced, analyzed emails that were allegedly sent by Frank Bybee, and even the digital forensic the digital forensic investigator, was able to determine that the particular emails from Mrs. Soule's email, of her AOL email account, came from Frank Bybee. So how can you come back from that as a defense attorney?
You really don't. You really don't. I definitely see a person who's trying to get out of trouble. I don't see necessarily attempted murder, but do I see elder abuse? There's a good chance of that. There's a good possibility that the jurors could make findings of guilty for something like that. There's nothing you can do with the fact that the IP address generated from his home. Well, who's to say he wrote that or he didn't wrote that? We don't know who did that. Well, who was there to write these things? It's an absolute. It's probably the most devastating piece of evidence that the prosecution has against the defendant here. No question.
Right. We also know that Frank Bybee's wife testified during this trial, and that's not something that you see often because of the usual husband-wife privilege. Before we get into what I want to discuss regarding her testimony, explain to our viewers the privilege between the spousal privilege.
Well, I mean, if one spouse doesn't want to testify against another spouse, they don't have to be required to do so. Here, of course, that's not an issue, and she's chosen to give testimony here, and maybe that's what happens when you marry law enforcement. You don't like your spouses.
Well,
no, it's not true in every case.
No, of course not.
I get in trouble here, but not all marriages are built the same.
Right. No, I understand that. But I was thinking that maybe, I don't believe she really went into much of their conversations. And a lot of the times the spousal privilege deals with conversations that's had between a husband and a wife and vice versa.
Correct.
She pretty much discussed the fact that Frank was out of the house the night of that Miss Soule alleged that he went into her house to allegedly conduct these acts, and that he arrived home when she awoke at 3 o'clock in the morning. He was back in the bed, but she did hear some rustling and tussling in the garage. The fact that a wife is testifying against her husband, how does that? If I'm a member of the jury, I would look at that and say, well, that doesn't look too great.
Right, the timing is terrible.
Right.
The timing's terrible. It fits when this woman was allegedly attacked. Absolutely awful. And it is the wife testifying against the husband. Again, I still don't think it's going to be enough for the attempted murder charge, but clearly he was up to something that he shouldn't have been up to, let's say. And of course, the jurors aren't supposed to assume things based on the fact that the defendant didn't testify, but the fact that you have the wife there giving this timeline to the jurors,
right.
It's another hurtful fact. And this is the problem, which is being defense attorneys versus prosecutors. It's just, you just have to live with what the cards you're dealt.
Right. Now, the state wasn't allowed to bring in testimony regarding another lawsuit that's at issue as well. They weren't allowed to talk about that during the criminal case. However, we know that Marsha Soule, even her doctors have said that she may have some type of mental issues. I know that we talked about some hits to the defense, but isn't that a big hit to the prosecution here? The fact that the defense in their opening statement stated that she's a Jekyll and Hyde. Miss Soule is a Jekyll and Hyde type of an individual, meaning that she kind of has two personalities. And the fact that it was brought out during testimony from her own doctor that Miss Soule has or has the potential some issues to play for the state in this, especially since when the sheriffs first arrived at her home during her first complaint, she really didn't have many, much bruising, except for, I believe, maybe a cut on her lip. And then when they returned, there was all this bruising on her arms. I mean, how does that play out? Does it make her, does it lead the jury to find that she's credible or not?
Sure. Or something like that. No, these are things that aren't helpful. Bruising doesn't occur right away, though. It takes a little bit of time. And so what the officer perceived a few hours earlier may not have been exactly how the, sorry about that. It may not be exactly how the bruise would end up looking. But, somehow she got those marks. It's unclear. She didn't state that initially that she was attacked by this officer. It appears to be by the treating physician. She didn't make any statements regarding that. So all these types of things are, of course they're helpful to the defense. Again, it almost appears as if the officer is trying to cover up a crime that didn't occur. With respect to, him going over there and, some kind of crime of attempted murder. I don't think that occurred. I think something possibly did occur between the two of them. But again, because of mental health issues, I don't think the state's going to sort of get over that hurdle and be able to prove beyond a reasonable doubt with all of this. No, I don't think so.
Right. Now, as I previously stated, the defense stated in their opening statement that Mrs. Soule has a Jekyll and Hyde personality. To me, that's putting the victim's character, in essence, at issue here. What do you think about that? That's something that I would, as a prosecutor, I would have objected to during the defense's opening statement. But I believe they got away with it. So what are you thinking about that?
Well, I mean, my favorite expression in this business is you play for the fumbles. Okay, so this is a mistake, and this was heard before the jurors. I would think that it would be, obviously damaging to the victim and the alleged victim in this case. Anytime a jury hears that a person's not necessarily believable because they have some sort of a split personality, I mean, they have to take that into consideration. And like I said, because of that, because of those kinds of statements, because of the testimony of her friend who testified, I don't think that they're going to be able to, hit every single crime in this case. But I think that there might be a case, for elder abuse and forgery and fraud and things like that against the officer. Sure, he's probably going to, he loses his job over this one, but he doesn't go down in the biggest way. He doesn't get life here. I don't see it.
Right, and I have to agree with you as well. I don't think that a lot of the elements that were described during the jury instructions were proved beyond a reasonable doubt by the prosecution here in this case. But the exploitation of an elderly member, I do think that is something that the prosecution did prove beyond a reasonable doubt. One thing that I want to also discuss with you is the fact that the defendant, Frank Bybee, did not testify in this case. We have here an individual who was a sheriff, I believe, for a great period of time, and he's not taking the stand. Now, we know that a defendant is under no duty to do so, but I can't help but think a lot of the members of the jury would probably have wanted to hear from him.
Oh,
what are you thinking?
They would want an explanation for this timeline. They would want an explanation for the fact of the matter that this incident occurred around this time. He wasn't home at this period, and then he returned several hours later. Well, where was he? Of course, if I were one of the jurors, I would love the answer of that question. Make things clear to me. It would help me in making a decision in this case. That's probably the big reason. Maybe he didn't have a good answer for it, why we didn't hear from him in testimony in this case. But nonetheless, he would have been crossed with all this documentation, these checks. Is this you? Is this? I mean, it probably would have been a disaster. So I think that I would say that the defense made the best decision in not calling him as a witness. Victim of her not being entirely credible because of, let's say, mental health, because of her age, or mental health because of some other, health reason that she has. And sort of play around the fact that, well, they had this existing relationship, things that might establish other convictions, but that won't get them to the big conviction that they want in this case. So I think they made the right decision. And are the jurors going to consider the fact that the defendant didn't testify? I feel like the judge tells them they're not supposed to do that.
Right.
I feel like after every single jury trial I have, the jurors always say, well, we weren't to consider that. We decided not to consider that. So I feel like the jurors often follow the instructions, but but on a case-by-case basis, of course, some jurors are going to use it against the defendant. Can't be helped.
Right. Now, I know that we only have you for a few more minutes, but 3 points that you would like to hear from both the prosecution and the defense tomorrow.
Well, I mean, I would like to 3 points from each. Well,
no, just the defense. I'm sorry. Just from the defense.
3 points you want to hear from the defense?
Yes.
Well, I guess I would want the defense to raise the fact that that this Dr. Jekyll and Mr. Hyde personality, this person who's forgetful, her initially meeting with I think Detective Allen in the beginning, him not seeing these bruise marks, what occurred, her friend who didn't see these things, although these pictures were presented to her later, she said, well, I just assumed it was this. If it were bigger than it was, I would assume that a friend would make a statement and say, hey, I saw something real here. It appears that she had been attacked. Those are the types of things that I would raise in this case. I probably wouldn't be able to hit so much on with respect to the forgery and the financial frauds that are occurring in this case, but I would touch upon the other things. I would accept the convictions in the other matters. You just sort of have to play with the cards that you have. I know I've gone further than that, but for the bigger crimes, they're not going to get them.
Right. And, Adam, it's always great having you on the show with us. Always providing some great legal commentary and analysis. Right. So thank you so much for being with us today, and we look forward to having you on the network again. Thank you so much.
All right. Signing off.